Apa lagi Jun?
May I please, Your Lordship?
Yes.
That's item number 14.
Yes, please.
Your Lordship, due to some personal difficulty, the engaged counsel could not appear today.
This, what is the application about?
There is no
Delay condonation.
condemnation. Delay.
Or it stated that the arguing counsel is not available today because of personal difficulty, and a request is made to adjourn the matter. List after 2 weeks.
Highly obliged, Your Lordship.
Lordship, with regard to item number 3 and 4, Lordship, I.
3 and 4, let the matters be called out, madam.
Lordship.
Item number 9.
Yes, Mr. Kalsi. Why you are seeking adjournment? Have you filed the amended petition? Have you filed the amended petition?
I have already filed the.
So then why you seeking adjournment?
No, your lordship.
Then matters have not been called out.
Oh, sir.
My lord, may I beg to mention item 24, my lord?
Yes,
In
please.
fact, this is a criminal appeal by a life convict, my lord.
Mm,
Now, my lord, I have been appointed as the amicus curiae. Now, pursuant to the order of this honorable court on the earlier occasion, there is a move on the part of the district jail authorities, my lord, for remission of the sentence of the appellant, my lord, convict appellant. Now, only dependency, my lord, has come in the way.
Okay,
Lord, I have received a letter.
right.
So lordship will adjourn it for at least 2 months with an observation, my lord, that this pendency of this appeal, my lord, will not come in the way for consideration of the application for remission, my lord.
Then amicus curiae, Mr. Talukdar submits that the appellant has served sentence of nearly 19 years, 18 and a half years by now, and that his case is pending consideration of the authorities for grant of remission. He, however, urges that the process is being delayed on account of the fact that the appeal is pending. So why don't you argue the appeal and get it disposed of? So then that process will otherwise also, you want the appeal to be disposed of as infructuous. Why?
No, I'm not on that.
Then argue the appeal, it will be disposed of, that pendency will go.
Correct.
Then
Well, in that case, can it be day after tomorrow, my lord, on Monday? I'll argue in this case.
what is the evidence? What is the
In
allegation?
fact, the only piece of evidence is 164 statement. And I have argued before this honorable court, the confessional statement, my lord, is not in accordance with law. So
Confession
therefore,
of the accused himself.
my lord.
Well, who has he murdered?
My lord, in fact, 3, my lord. In fact, there was some, my lord, he was not in a mental, my lord.
All right, then mental 328. Okay, right. He thus urges that the hearing of the consideration of the appeal will be deferred with an observation that pendency of this appeal will not act as an hindrance in the way of the appellant to seek remission. The submission so made is noted. The consideration of the appeal is deferred till 14th September with an observation that mere pendency of this appeal shall not act as an hindrance in the way of the appellant to seek remission in case he is otherwise legally entitled to do so,
Okay.
to claim such benefit.
Obliged.
May I please, Your Lordship? My lord, I beg to mention item number 27, my lord.
Mm.
I'm for the petitioner, my lord. I prefer only 2-day accommodation, my lord. Our brief, my
What is the PIL about? PIL for in hearing, what is the matter?
lord, regarding my lord, encounter, my lord. Regarding,
PIL, what PIL has to do in encounter cases?
my lord, in car movement, my lord, there is an encounter, my lord.
All right, counsel for the petitioner submit that he is not prepared today and seeks an accommodation list after 4 weeks as prayed.
Highly obliged. May it please, Your Lordship. My lord, I may be allowed to move one urgent read appeal today at 2 p.m. The urgency is that, my lord, we have approached challenging a tender process before the learned single judge. Learned single judge, by an order dated 31/7/23, recently, my lord, has refused to pass an order. My lord, the financial bids are going to be open today. If the
Refuse to pass an order means?
my lord, we were disqualified for technical bid for the reason that one of the director had some pending work, and they have included the pending work of the director as a work of the company, my lord. On that ground, my lord, our technical bid was rejected. Learned single judge, my lord, failed to appreciate in proper perspective. And my lord, they are going to open the financial bid today in the second half, my lord. There is urgency, my lord.
So the order was passed on 31st July, you say.
31st, my lord.
All right, very well, get it listed. Why not tomorrow?
My lord, kindly financially.
There must be a caveat.
My lord, till now we haven't got, my lord, because we have already filed. My
Hmm.
lord, also will take up at 2, my lord.
Very well.
Kindly
at two.
consider.
Come on, come at.
Highly obliged.
May I please, Lordship? I beg to mention item number 26, my lord. I am
Yes.
for the respondent, my lord. I have taken consent from the.
Counsel for the respondent has moved an adjournment slip. The appellant's counsel does not have any objection. The prayer for adjournment list after 4 weeks.
A date may be his lordship, item number 26, I'm the petitioner.
26,
Yes, my lord. It says the.
you are the petitioner. List on 20th September.
May it please your lordship.
Yes.
Lordship, I beg to mention item number 18, lordship, 18, lordship.
Mm,
In this matter, senior counsel PJ Seta has been engaged, lordship.
Mm.
Justice Khan may not like to take the matter.
List before a bench of which. List before a bench of which. Honorable Justice SP Khan is not a member.
Lordship.
Mm,
Lordship, for listing of retailers, Lord, and against a common judgment and order, Lord, we have prepared 14 retailers, Lord. We filed on 26th of July.
mm.
Some defect was there, we have cured, Lord. I pray for listing on Monday.
List on Monday subject to removal of defects,
Lordship.
if any.
Hamlet.
Daily list for orders, item 9.
Well, see, how is your trust connected with those complainants whose complaints you have annexed on record? Can you let us know? There are few complaints which you have filed. How is your trust connected with them?
Your lordship, the members are there, are members. They
Well, The
were,
complaint is not by the trust.
the
That
complaint
that
has
is
been
by
lodged-
some individuals.
The complaint has been lodged by the trust, no doubt, your own lordship.
Then,
But in the individual capacity, they have filed certain,
so individual
Complaints.
capacity, how does the trust seek access on the basis of these complaints?
your lordship, that is, the complaints were filed by the individuals, no doubt in it.
Then
But being the members of the council, that is. of
where is
trust.
where is your pleading that the complaints were filed by the members of the trust? Let us see. Pleading, please.
That statement has not been made.
And Mr. Kalsi, this
That
is,
statement has not been made.
then better it is you withdraw and file a petition with the better pleadings.
Liberty may.
That is
be-
your choice. We are not forcing you to
liberty
do
may-
it.
Liberty may be granted.
That counsel, Mr. Kalsi submits that the petitioner trust would be better advised to withdraw the instant PIL and file a fresh one with better particulars oblique details. Better particulars oblique specific details. In view of the submission so made, the instant PIL is disposed of as withdrawn. The peremptory cost to the tune of rupees 1 lakhs deposited by the petitioner in pursuance of the order dated 13/3/2023 shall be reimbursed to the petitioner.
All right.
Keep living.
All right.
Item number 10.
But this appeal may come up along with the other appeals, Lord. I have just mentioned on Monday.
So you want this matter to be listed on Monday? But
Lord,
what about service?
for service we have served, Lord. Dusty we have taken. and
For the respondent.
We have filed the affidavit.
All right, Counsel Mr. Sonjo appears on behalf of the respondent.
Number one.
Thus, service is complete. Re-notify on Monday.
Much.
Interim order shall continue till next week.
Lord. All right.
Item number 11.
Please, Lordship, my lord, here is two IA in the PIL, my lord. IA number, IA, my lord, 2136 will file, my lord, to implead the respondent, my lord.
2134 or 2136?
2136, first one, my lord.
Yes, for impleadment
For
of
implement of the respondent, opposite party 11 to 36, as the respondent 11 to 36 in PIL, my lord.
you have impleaded 36 persons.
My lord, no, my lord,
There?
26, my lord. 11 to 36.
Why impleadment has been sought,
All
sir,
the members, elected member of the council.
of the
my lord.
council?
My lord.
So we will have to issue notice of the IA, issue notice of the, what is the other IA about?
Other, my lord, regarding amendment of the my lord, the petition, my lord.
So you want the amendment to be done first or notice to be issued first?
Amendment first.
Then go for amendment first, my lord.
All right, do you object to the amendment?
My lord, amendment, my lord.
What is the prayer basically in the, Mr.
But
Sarania,
all the amendment has been, my lord, indicated in paragraph number 6, my lord.
of the
6 of the, my lord,
application?
my application, my lord.
So then you will have to file an amended
My
petition.
lord, by 15 days I'll file. By Monday I will
The
file.
fresh petition you will have to file.
My lord, my lord.
Yeah, IA number so and so has been preferred. IA number 2134/23 has been preferred by the petitioners herein seeking amendment in the main PIL petition number so and so. And standing counsel, Mr. Chutia, appearing for the respondent counsel, does not object to the prayer for amendment.
My lord.
Hence,
My lord.
comma, the
My lord, the prayer, my lord, he has made, my lord, by this petition, my lord, he wants to, my lord, cancellation of the election, my lord. So there is a procedure, my lord, so we have to file, if that amendment is there, my lord, paragraph 5, my lord, page 31.
just hold on. Huh? Yes, right.
To direct the respondent number 2 to call for the fresh election,
So that is the prayer in the amendment application.
my lord.
So we are not accepting the prayer as such. Now this prayer will be incorporated in the amended petition.
My lord, my
We'll
lord,
take it up. This is just now only the prayer for amendment in the pleadings.
my lord.
Thus the application. No renumbering business, fresh petition you will have to file, complete, incorporating all these things. Renumbering business causes a big confusion.
My lord,
So we'll direct you to file a fresh amended petition,
my lord.
incorporating all these things.
My lord, then the paragraph will be changed, my new paragraph will come.
Everything, the entire petition will be
Fails.
a fresh one.
My lord.
It's rather better you withdraw this and file a fresh one. That is always better. What is the use? Otherwise also you will have to
My
file the
lord,
multiplicity.
there is an effective order, my lord, the outcome of the, my lord, the PIL, my lord, that order to have to prevail.
All right. Otherwise, does not object to the prayer seeking amendment in the pleadings of the PIL. Thus, the amendment application is allowed. The petitioner shall file fresh amended petition incorporating therein the specific averments made in the amendment application only. Nothing beyond that.
My lord. I love them. Then
Needful be done within 2 weeks.
other will be, my lord, remain pending that other.
The other application that will keep
My lord.
be pending. 2136.
I love that.
The IA 2136 and PIL 15/22 list after 2 weeks. Simply.
I love them.
Item number 12 and 13.
Striking of and impleadment.
Yes, Lordship, because respondent number 15 died before filing of this appeal. That fact was not aware by the appellant, Lordship.
IA number so and so has been filed by the appellant herein seeking striking of the name of the respondent number 5
15.
and 15 and impleading on the ground that that such respondent had expired before filing of the it's a writ petition
Appeal, Lordship.
appeal, which fact was not in the notice of the appellant, and for impleading his LRs as party respondents number so and so. You appear for
Respondent number 1 to 14.
1 to 14. The notice of the application will go to the LRs. That notice of the IA number so and so to be issued to the respondents
And 15.
sought to be impleted, that is 15A and 15B. The prayer for striking of the name of respondent number 15 is accepted.
Diploma.
Item number 15.
May I please, Your Lordship?
Yes,
Lordship, the IA is for condonation of 59 days delay in filing the writ appeal, Lordship.
what do you say? Interlocutory application number so and so has been filed seeking condonation of delay of 59 days occasion in filing of the connected writ appeal. Learned Standing Counsel, Mr. Your good name, sir?
P. Sharma. P. Sharma.
P. Sharma, appearing for all respondents.
No, my lord, I am one and five only.
Respondents number 1 and 5. Who will be appearing for the other 3? Dima Asao.
Also another counsel.
Then notice will have to go, madam. You are appearing
I am appearing for.
for the response numbers 7 only. What about the response numbers 2, 3, 4 and 6? The notice will have to go, madam.
Lordship, they have their council, Lordship, I will serve notice to him,
Let the standing council come.
Lordship.
I already issue notice to the response numbers 2, 3, 4 and 6. The service be effected by supplying, providing copy of the IA to Learned Standing Council concerned. List after 1 week.
Item number 16.
May it please, your lordship. The lordship permits us to take fresh steps on response number 7. Lordship, I'll be grateful. Your lordship. There was
You have to
time-
take fresh steps
Yes, sir. Lordship.
in council for the petitioner. To take fresh steps.
On response number 7, your lordship.
For effecting service on the respondent. Who is respondent number 7? District judge. Why, what is the petition about?
Your lordship, the petition is about supersession of the petitioner, your lordship.
All right. Fresh steps for effecting service on the respondent number 7. Within 7 days, whereafter process be issued to such. Okay.
Item number 17.
Where are the councils from the other side? What is the matter, sir?
Well, this is a matter which might be filed against the rejection of the interim order. Now, below the question is that below the 26(1) under the Competition Act, the Competition Commission of India has the power to direct for investigation. Now, on forming a prima facie case. Now, in this case, my lord, there was a direct decision of the apex court, wherein said, my lord, that if the item in question, the purchasers and suppliers are very limited, then quoting of the same price will not amount to price again of castration. Now, that decision was placed before the Honorable Single Judge, my lord, and that decision, my lord, from the appeal went to the up to the Supreme Court, my lord. Now, the Single Judge held, my lord, that since in that case, against the final order, the matter went to the Supreme Court, and here it is against the 26(1) order, that is the directive for investigation, and thereby that Supreme Court decision will not be applicable. My lord, the Supreme Court decision, whatever is there, the law which has been laid down, it cannot be said, my lord, that will not apply in the earlier proceedings. And somebody had to go with the entire process, and then only the same will be applicable. Your lordship may kindly see, my lord.
Let the other side come. Dr.
My
Saraf.
lord, my lord,
Paso.
my lord.
We will re-notify it in the next week then. List on 9th August, the
No, not 9th, my lord, I said, problem. My lord, I said 8th or 10th, my lord.
10th August, the standing council concerned be intimated to remain present in the court. You have served the copies?
My lord, yes, sir.
Copies of the petition have been served on the standing council concerned. They shall be intimated to
I said,
attend the appear on behalf of the respondents on the next day,
we shall inform him also, my lord. I am obliged.
10th August.
Item number 19.
Which challenges the provision of the Provincialization Act, 2017 before the.
Yesterday, there were some matters.
Yes, but now it goes before the special bench.
Special bench, we've already sent the other matters. No,
The other matter was regarding to the provincialized service rules.
service
This is with
rules.
The Provincialization
This
Act.
is the act,
Act.
issue notice to the respondents, steps of service will be taken in 3 days, placed before the special bench constituted for hearing matters pertaining to provincialization.
Obliged.
Item number 20.
May I please allow?
Yes, please.
Here for the responding number 1 and 3, my lord. A copy has not been served.
Lordship, I served the copy of PDF, Lordship, on 24th July, Lordship, to Mr.
E-service.
He provided it to him, my lord. He appearing.
He assured me that we will serve the copy, Lordship, because. of this-
Council, please provide a copy.
Lordship,
E-copy will work,
Lordship,
but you have to give it to him.
Lordship, I'll serve the copy.
You have to serve the copy to
by
Mr.
now,
Das.
Lordship.
Then council put the petitioner to serve the copy of the petition to learned council representing respondents numbers 1 and 3
1 and 3.
by e-process.
Lordship, by 2 days.
Serve a e-copy of this one.
Lordship,
within 2
I'll
days.
serve the copy, Lordship.
List after 1 week.
Deeply obliged.
Deeply obliged.
He's.
Right. Item number 21.
Yes, what is the petition about?
Lordship, I have challenged the order of detention, Lordship, issued
Detention.
against me.
All right, replies here.
Yes, reply file.
Yes, what are your grounds, please?
Basically on 2 ground, Lordship.
Yes.
First ground is delay, Lordship. Actually,
Delay in what? Delay in passing the order.
Passing the order and actual arrest, Lordship.
Oh, so delay in execution.
Execution, Lordship.
Okay. Okay.
Lordship, there is a settled position of law, Lordship, that
Let
is.
us see your ground first.
Yes,
What is the delay? How much is the delay?
Yes, Lordship, order was issued on 29/12/2022, Lordship.
And execution in
Execution on 17/2, Lordship.
17 to 3 months is not a delay, madam.
But Lordship, in this regard, there is a judgment, Lordship.
We
by
will
the-
see, we'll see the judgment. Let us see your ground first.
Yes, Lordship.
And
And second one is, Lordship, that he was detained because of 2 criminal cases, Lordship, pending against him, Lordship. That in 2 criminal cases, Lordship, he was already granted bail by the honorable court. And
grant of bail is,
Lordship, Lordship, evidence is going on, Lordship, and there is no whisper that he has, Lordship, violated any condition of the bail or he has absconded, Lordship. And Lordship,
Yes.
bail was granted, Lordship, because there is no intimating materials was found against him, Lordship. I have annexed the bail order also, Lordship. That's why he was
Alright.
granted bail, Lordship.
let us see the grounds of detention then.
Yes, Lordship, that order is page 17, Lordship.
Mr. Paras, sir, you are prepared? They have taken a ground of delay in execution.
Delay in execution is, yes, the executing authority is the state, DG, we have immediately, and regarding service 17, we have, he has prevented, and on the same day, notice of serve upon him, the order.
17,
2.
so the order was passed in December.
Yes, but executing authority, is the response number 3,
So they got the order on 17.
No,
Then?
prior to that, no.
Yeah, all right, we'll see that. Okay. Who is the detainee? Lakhandas is himself the detainee?
Yes.
Okay. Yeah, this is how this is happening. Come to page 21, para 16. The High Court rejects the bail, saying that no case for bail was down. And then the additional session just grants bail. When we have conducted this. People have lost job. Let us see the order. Where is this bail order in bail order dated 16/7 granted by additional session judge Rangia?
Page 51, Lordship.
51. Let's see.
In this case, he was arrested, shown arrest, Lordship. Romania case.
This has been granted on ground of 437(1) without considering the fact that the High Court had rejected the bail.
That is on medical ground, Lordship.
Yes. So he was granted bail on 16/7/22.
Yes, another Lordship, earlier Lordship on 3/3/2022, page 46, Lordship. That is the Karbi Alam case, Lordship, Dipu, Warpathar case, Lordship. Page 46.
BP submitted no objection.
Yes, Lordship. And Lordship, no incriminating materials were found, recovered from him, Lordship.
Recovery is not necessary
Yes,
to implicate a person in the narcotics
Exactly,
case.
Lordship.
Sixty-four packets of heroin. My goodness. Yes. So your ground is only delay in execution.
Yes, Lordship.
That's the only ground.
And Lordship, regarding criminal cases, Lordship, he is not absconder, Lordship. He
Doesn't
is-
matter the
Yes.
satisfaction, how the subjective satisfaction of the authority.
That's judgment I want to place, Lordship. Supreme
What
Court
judgment, madam? Please read the ratio.
Paragraph-
Don't throw across the judgments like this.
Yes,
What is
sir.
the ratio of the judgment? And
paragraph-
where is the list? Have you given a list of judgments?
Lordship, I have, these two are with me, Lordship.
Let's see. Have you provided the citations to the standing council?
Paragraph 20, 23, and 26, Lordship. Under similar circumstance, Lordship. The maximum liable cost, proximity link, Lordship, that is there. Lordship.
The delay in passing of the order, not delay in execution.
There is execution also, Lordship.
No, read which para?
Paragraph 15, Lordship. The adverse effect of delay in arresting a detainee has been examined by this court.
All right, in this case,
Yes.
what was the delay? What was the delay which was treated to be fatal by Honorable Supreme Court?
Lordship, from the date of proposal, then date of.
That is delay in passing, madam.
Passing, yes.
Where is your ground in this petition? That there has been a delay in passing also. Where is the ground?
Yes, Lordship, I have mentioned, Lordship.
Let's see.
Paragraph,
Read it.
Lordship, 16.
6016.
16.
Let's see.
Lordship.
Yes,
There are unreasonable.
that is only in ground regarding execution, delay in execution. This is hardly anything, 1.5 months. That can't be treated to be delay. Give one judgment of Supreme Court wherein 1.5 months a delay in execution has been treated to be fatal.
Then
You will not find one judgment. There is no question.
Then Lordship,
We'll give you dozen judgments against that.
then only, Lordship, I may be allowed next week, Lordship, I place. Next week, any date. Lordship.
Hardly anything, madam.
29 to 12 is the order and Governor Basam received the order on 2nd of February. Almost 1 month. Subsequently, execution was in 15 days.
What is your explanation? You have given this explanation in the reply.
No.
That delay explanation I have not given, but I have written that in my affidavit that execution authority is the state, my lord. And
There are 29, they are reply, Lordship.
1.5 months is never, can never be considered to be delay, madam, otherwise also.
and
The
immediately. on
cases,
the-
Supreme Court judgments on a delay in execution are those wherein there were years and years of delay in execution. 1.5 months is never a delay in execution.
Next week, Lordship.
He has a great propensity for narcotic smuggling. All right, you bring the judgment. We'll also settle the law so far as the state is concerned. 1 week has paid.
I'm obliged, my lord.
Supplementary list, item 31.
Made, please allow.
Yes, please.
My lord, the matter relates to supply of furniture to a particular school. Now, we filed a writ petition, my lord. Our grievance was, since I am the L1, the authority should issue the work order. Now, my lord, the learned.
Why your
student-
bid was not accepted?
No, my bid was accepted. Work order was given to me.
But then?
Now, another writ petition was filed by the L2 bidder, my lord. His grievance was that the samples which I have submitted, it was not, conforming to the requirements.
Okay.
Now, my lord, learned single judge did not go into the merit as such, but on the ground that we have suppressed material fact, my lord, my writ petition has been dismissed. And my lord, the
Just
other,
hold on. Why writ petition was not yours? You filed writ petition.
I filed writ petition 1, this L2 bidder also filed a writ
Why,
petition.
why were you
He
required to file?
challenged the, my lord, work order given.
Why were you required to file the writ petition?
I filed the writ petition because in spite of being L1, I was not given the work.
You just now said that work order was given.
No, subsequently it was given.
It was-
Yes.
Subsequently.
Initially, when I filed the writ petition, my lord,
Hmm.
work order was not given to me.
So then
Now, my lord, if a lordship should kindly come to
just
the,
please clear the things
Yes.
once more. So work order initially was not given.
not
You
given.
filed a writ petition,
Writ
then what
petition.
happened?
Then, my lord, yes, there is an intervening development. If a lordship should kindly come to page number 77. And the operative portion is at, my lord, page 78. This order, my lord, took care of that aspect regarding the sample. Now, if a lordship will kindly come to this first subpara, the matter pertains to a tender process initiated by the NIT dated so and so for supply of school furnitures for respondent number 5 school. It is the case of the petitioner in the first NIT bid of the
The first
petitioner.
NIT was cancelled.
That was cancelled. There is
Second
no
NIT
dispute.
was issued
Yes.
wherein again.
Again, I was.
Hmm.
The case of the petitioner is that in the second process, the bid submitted a petitioner has emerged as L1. However, there is a note by an authority recommending rejection of the on the ground that supplies of
Inferior
samples are of
quality.
inferior quality.
Right.
The learned counsel for the petitioner submits that apart from the fact that very
A
less
decision
time
had
was
not been
granted
taken. Okay,
for making the supplies of the sample, the recommendation is not on the basis of quality, but certain lack of fittings which could not be done because of constraint in time. On the other hand, Bothakoti learned counsel for respondent number 5 submits that the authorities were competent to take the decision or yet to take such a decision, and matter is only at the stage of recommendation by the additional deputy commissioner. Be that as it may, this court is of the opinion that the dispute may not be required to be adjudicated in view of the direction which is proposed to be passed. This court is of the opinion that petitioner be afforded with another opportunity to place the samples of the supplies which he proposes to
was
make
this
in a-
permissible, sir? Was this permissible?
Well, this order-
Second opportunity to give a sample,
Well,
was
this
this?
order was not challenged by anybody. This is attained finality, my lord.
Okay. Very well.
From
Then what
today,
happened?
there will be a fresh inspection, assessment of the supply made. Actually, what had happened, my lord, the order was given to me on 14th. I got only 2 days because Saturday and Sunday intervened.
Mm.
So therefore, my lord, all samples I could not give, some of them I give.
Samples were not required to be given before
But
the,
as per the tender, it was not required, my lord, but their authority insisted.
all right.
Yes,
Then what happened?
yes. So it is needless to state such a decision be taken independently and fairly, and outcome may be informed to this court by the next date fixed.
Then
Well,
your-
after this order, my lord, I was permitted to give this sample. Thereafter, on 19/4/2023, work order was given.
Work order.
Now that
19/4
work order came
23.
to be challenged by the
Order.
L2B.
And what is the ground now?
Yes. Now, my lord, if a lordship would kindly come to the
Why Union of India is involved in it?
scheme of Union of India.
Scheme is of Union
Yes,
of.
yes. Now, what had happened, if a lordship will kindly come to the impugn order, my lord,
Yes, please.
that. Just a minute. Page number 127, it starts, but I'll have your lordship's kind attention to
Yeah.
page 141.
Para, please, para.
Yes, my lord, 141, one second,
Paragraph.
one second. Paragraph 20.
Hmm.
In this case, the petitioner in WPC number has suppressed the material fact and did not disclose the true state of affairs relating to inspection of samples furniture carried out on 19/12/22. Although the said writ petition was filed on 21/12/22. Under such circumstance, the respondent number 6 has become disentitled to any relief, and the writ petition deserves to be dismissed on the ground of suppression of material facts which had bearing in this case. In this regard, with profit, we may refer to so and so. The writ petition was dismissed with exemplary cost of ₹1 lakh because in the list of dates filed with the petition for special leave to appeal, fact that the first respondent had been reinstated in service or that his service has been regularized had not. And my lord, that was a case where for non-disclosure of facts, my lord, the petition was not entertained and cost was awarded. Then my lord will kindly come to page 143, para 26. After quoting the Supreme Court judgments. It is reiterated at the cost of repetition that in this case, the inspection report dated 19/12/22, where respondent number 6 or his representative was one of the signatory, was withheld from this court. The only presumption that can legally be drawn is that had the said report been annexed to writ petition, the same would have been adverse to the respondent number 6. Moreover, in the letter dated 19/12/22, the respondent number 6 never took the plea of wanting some more time to supply furniture, furnished furniture samples, which was portrayed as if the respondent number 6 was seeking more time to supply furniture. So, my lord, essentially the writ petition was dismissed on the ground that I suppressed this
Suppression of
1912
fact.
Yes. Now, let me place the facts, my lord.
Yes, please.
Now, first of all, my lord, it's a fact, my representative was asked to put his signature. If your lordship will kindly come to page 144, my lord, 147. My lord, when my representative gave the samples, my lord, he was asked to put his signature. He put his signature from the left is the, my lord, third. Iqbal Hussain.
JMK. For JMK.
For JMK. Yes, my lord. Now kindly see, my lord, these columns were not filled up because my representative, my lord, when he put his signature, he took a photograph. Now, eventually, what has been annexed to the writ petition by the other side is page 148. These were all inserted later on, my lord. And my lord, it was never informed to me, so I could not. But nevertheless, my lord,
You are aware of the fact that an
Yes,
inspection
I
has taken
mentioned.
place.
I have mentioned in the affidavit, learned single judge has not taken note of that. Please come to page 114 in my affidavit, my lord. My lord, it was nobody's case that there is a suppression of material fact. There is no pleadings in the writ petition, my lord. Please come to para 11. I have never suppressed anything, my lord.
Yes, please.
That the deponent begs to state that although seeking of sample is not provided in the tender or guideline, however, deponent agreed to deliver a sample for assessment. Deponent had only 2 working days in hand, that is 16 and 17, 18 is a Sunday, to prepare the sample. However, the deponent tried his best to provide the required samples, but could not achieve the mark of satisfaction from the
Very
authorities.
couched kind of language, Mr.
No, but,
Chaudhary. Where is the fact that the inspection took place on 19th? Why didn't you mention it? So if this
My
fact
lord-
had been brought to notice,
Ah.
the order permitting you to go for a fresh inspection or for an inspection
Okay.
would not have been passed.
Okay, Lordship
That
will
is-
kindly come to the order dated 31-3. What was my case?
Yes, that's.
Same case, my lord. Page number 79.
Hmm. Just, and what is this order of third? May?
Kindly come to page 78, my lord.
Yes, just a moment.
The learned counsel for the second subpara, my lord. The learned counsel for the petitioner submits that apart from the fact that very less time was granted for making the supplies of sample,
Hmm.
recommendation is not on the basis of quality, but certain lack of fittings which could not be done because of constraint of time.
Hmm.
My lord, it was also of my case, my lord. My lord, in fact, my representative has filed an affidavit. He has shown an affidavit to state that this fact was not informed to me, that his signature was taken. Because where he was informed that the fact that you have given some sample, put your signature. That is why, my lord.
That
No, my lord,
ignorance,
see, my lord,
Mr.
is
Chaudhary,
it-
that ignorance we will not accept.
Okay, okay, my lord.
That ignorance of a
Whose
businessman,
case is it, my lord,
That-
that there is a
that's-
suppression of
that's a
material?
different fact. That's a
Yes.
different argument.
Yes,
We'll hear you on that.
yes.
But this ignorance part, business will not accept.
Anyway, okay,
That please,
Lordship will
please.
not take note of that.
Yes.
But there is absolutely no suppression, my lord.
Hmm.
In the affidavit filed, when they annexed that document, my lord, we filed that our amendment was very specific in paragraph 11. That because of constraint of time, we could not.
All
make
right.
this
Now, what is the stand of the authorities?
Authority.
Hmm.
No,
What is
authority.
the stand of the authority on this aspect or this state government, the procuring
Nothing,
entity?
Nothing.
They have not.
Assess nothing.
Okay, very well.
Assess nothing.
Now
Neither
let us.
neither the second L2.
So you have been non-suited only on this
Now,
ground.
what had happened? Partly I made supplies, my lord. Now what had happened? The whatever I had made. In the meantime, my lord, in the writ petition filed by the L2 bidder, there was a restraint order which has been now made absolute, and the authority has been directed.
3rd May 23, the restraint
Yes,
order
my
is there
lord.
by
Authority has
justice.
been directed to
Yeah.
go for fresh tender. My
Fresh
lord,
tender.
Yes. Huh? Fresh tender. Hmm? 1 second, my lord.
Page 145.
Oh,
On-
yes, there is another option is also given. Number.
Number 145.
Yes, yes.
146D.
My lord, the operative portions are at 145, direction of the learned single judge.
Competitive rates or a fresh tender?
Yes.
Hmm.
Options have been given.
Hmm.
Now, my humble submission is, my lord, what is the suppression of material fact to which I have resorted?
All
My
right.
lord, had it been a case that this 1912-22 document would have been marked to us, it is not marked to us, my lord. It is their document. It is in their possession.
Hmm.
Yes.
Just, hold on. After the order whereby you were permitted to give fresh samples, the order was passed on the premise that the authorities had not taken the decision as yet. Where is that decision thereafter to give you the work order? Where is that decision?
Yes. Page 80, my lord.
Hmm.
With reference,
Approved
to
for
the subject,
supply.
I have the honor to refer as per Honorable Deputy Commissioner comes so and so.
Hmm.
Approval for supply. Hence, you are hereby informed to supply the school furniture.
Right. Okay.
And my lord, page 81 is the list of
Articles to be
items which
supplied.
are supplied.
Yes.
Of course, learned single judge has not said anything regarding this, my lord, that
Hmm.
I'll forfeit my thing or something. But question is, my lord, since I was legitimately, my lord, given a work, I should be allowed to complete it. And my lord, that suppression of material fact is not.
Yes, all right. What do you say?
My lord, since in my writ petition, they were not parties, we have filed an IA, my lord, seeking leave to implead them. So now since he's
He's
there.
already there since he's appearing.
My
Yes.
writ petition is also not on record, my lord. There were some others, the guidelines which had come in record. But my lord, we'll leave it. What had happened here was, there was a tender wherein we both participated. Admittedly, he was L1.
L1, yes.
And I was L2. In terms of the guidelines, we were both asked to make our samples. I supplied all the samples. He supplied few samples. And my
He
lord,
supplied all samples. There were shortcomings
No,
in
no, no, he
the
did not
shelf of the
supply.
desk.
No, no, he did not supply. Around 15 were there. He supplied around 7, my lord. Others were not supplied. Samples were not given. Out of the 7 that was given, my lord, there were defects. And it was defect. He comes up before this honorable court. And the finding was that my quality was superior, his was inferior. That was the finding.
Okay.
He comes up before this honorable court, taking a plea that I was asked to give the samples on 19th. On 19th, and this letter was given to me on 14th. So because of the shortage of time, I could not give all the samples.
You were not made a party in his writ petition.
No, but the letters that were given to him, my name was there. In the statements are there, my lord. All over the statements are there making allegations against me. Now what happened, my lord? After that, I was waiting for my orders. Immediately in the month of April, I get a letter again that come again, and the next day submit samples. Now, I did not know what was happening. I wrote a letter that what is this? You have already done it, completed it. Why this? Then I filed the writ petition, my lord, because a work order was to be issued to him. I filed the writ petition. When I was moving the writ petition, I came to know from the respondents that there is already an order of this honorable. I brought that to the notice of the honorable court that my lord will not pass any orders today because there is a writ which is fixed on 3-5. Let both the matters come up on 3-5. On 3-5, the records were produced, wherein that inspection report was also there. And this honorable court, my lord, said, in the meantime, he had made some supplies. Okay, fine, what you have made, rest don't make. Then, my lord, the final hearing took place. And my lord would see, in the writ petition, there is not even a whisper that on 19th, these things took place. And now, my lord, after the passing of the order, a stand has been taken that the employee had gone. And the employee did not inform
that stand will not accept.
But there is not even a whisper in the writ petition. Now, my lord would see the operative portion of the order. Work was not given to me. 145, my lord.
Mr. Chaudhary, what is your explanation for non-impleadment of this respondent in your writ petition? That is a serious, very seriously viewed. Because he was a competitor, if your samples were not meeting, this was underhand dealing. You came to the court, conceal this fact.
I'll not run
on
away.
that.
I'll not run away from that fact, my lord.
So
Yes.
there is nothing, you can't do anything on
It
that,
was not
because
done.
had he been there in the writ petition, then probably this order might not have been passed, allowing you to a second sample, giving you a second chance. There was no possibility.
No, my lord.
Yes.
No, my lord. To that extent, yes.
Yes.
I agree, my lord.
We-
Ideally,
for
I
the
should have
moment
made him.
we ignore that part even of concealment,
Yes.
but still this non-impleadment is a clear-cut case
The fact that
wherein
he-
you have tried
The
to,
fact that he himself, filed the writ
that's a
petition.
different thing, but you procured an order without the competitor being in the picture.
131(3), my lord.
Yes. That is something which is very serious.
No,
To take a call now, what we are saying is one option is there before
there
you.
is- in the
One
tender-
option is, Mr. Chaudhary, if this order stands, probably you will be blacklisted, you will be debarred from further tenders. The easier way out is we make the cost easy, let the fresh tender go on. That is the easier way which we are suggesting. Otherwise, choice is with you.
No, my lord,
Very
to
well.
that extent, I cannot say no.
Yes.
But Lordship will kindly see what was the materials before the learned single judge to arrive at, my lord, had it been a fact that is 1912-22 proceedings would have been marked to us. If I would have
Question, you are
before
present,
that-
sir. You are present. The inspection part was a part of your process. It is not that you have been solely identified or
My lord will- my lord,
singled
for a-
out.
For a moment, Lordship will come to 147,
Yes.
page number 147.
Yes.
Kindly see, my lord, when I put my signature, what was there? When my representative put this,
This is before the starting of the process. You are conscious enough. Your employee just, and then you have not supplied the complete samples.
exactly.
So he has done it. So then
No, my lord.
where's the question of in a competitive process,
Yes.
when you have not supplied the samples as per the requirement of the tendering authority, then you are otherwise disqualified.
No, my lord.
Then you get an order.
Second column,
Ah.
my lord. It is clearly said in
What?
some of the samples I have given.
Quantity of sample that was nil at that stage. Forget about the comments and remarks
No,
came out later.
quantity of not nil, my lord.
Yes.
Supposing one I have given,
One,
three I
then
have
second you have
given.
not given. Out of
Yes,
15.
1, 2, 3,
Out of
4,
15.
5, 6, 7.
So you were disqualified on that very day, sir. So second chance you got by concealing the fact that there is another bidder who has given the samples. On that very ground, you are not suited.
No, my lord. Authority never took a decision to disqualify.
The
him.
authority could not have taken because this court gave you a second chance.
Even before
See-
31(3), authority never took a call to disqualify me on this count.
Could not have done because you got an order from the High
No,
Court.
I got this order on 31(3). This is of 1912.
Yes. So the decision was yet to be taken.
Yes.
So if the second chance had not been given to you, you were straight up disqualified. Plain and simple.
No, my lord, that I accept.
So then that you
But
accept that what is there?
non-impleading of him has a bearing
That's
in
a
this
fatal-
case that I will
fatal-
not say no. That is
Absolutely
for merely
fatal,
because
sir.
I am holding a brief, I will not make that submission.
Fatal, absolutely fatal. We are of the.
But my humble submission is, my lord,
Very well.
the learned single judge has proceeded on a premise which is non-existent, my lord.
So we will add to that non-impleadment is another charge of concealment or trying to mislead the court in this case.
That your lordships can
You
do.
know very well, Mr. Chaudhary, writing is on the wall. So
My lord will kindly come to page 120, my lord. Where is the requirement? Let us see, my lord.
you have
The
considered
CBC
to that,
guideline.
sir. You have considered, you have not come to the court on the ground that they cannot ask for the samples. You have sought a second chance. So that is acquiescence.
No, the second chance was given by the court.
Only because the court was not made aware that there is yet another bidder whose complete samples have already been provided.
In fact, my lord, as per
Why
this-
did you approach in March? Let us know. Your samples were taken in December. Why at the last hour you
No,
approached?
March not the first time, my lord. Prior to that, I approached.
When did you file the writ petition?
Writ petition to be
Well,
filed.
there is an interim order on
21/12, we filed the writ petition.
22/12/22.
21.
There is an interim order.
There is an
Of-
interim order in his favor.
Yes.
22/12,
Not proceeding with the tender.
not proceeding with it.
I approached earlier, my lord.
Why were you supposed to?
21/12, I approached.
Why? On what
Because I
ground?
was apprehending, my lord.
You were apprehending because your samples were not complete. You knew very well. That sheet, forget about the comments.
That I partly gave the sample. That aspect I have never withhold from
That's
anybody.
what we are saying. You very well knew that you did not give the complete set of samples. You will be ousted. So you came to the court, not impleading your competitor. That's enough ground, sir.
That aspect of the matter was highlighted by the principal of the school. The court felt if that 31(3) order has attained finality, by that order, this honorable court said
That order has attained finality without hearing the party who was necessary. So that order ultimately merges in the final order.
True.
And that final order is before us, and we find a stark concealment on your part in addition to what has been observed by the single judge. The sequence is very clear. 1912 samples are given. You very well know that your samples are not complete. You will not clear the process. So you come here in apprehension and in anticipation, file a writ, get a
My
stay.
case was under the tender
Let
conditions.
us see your pleadings in the writ petition.
Yes,
That why you were required to come to the court.
yes.
That you just give an explanation orally. Why were you required to come to the court? In right after 2 days of the sampling
Yes.
process
My
having taken place.
petition is at page number, my lord, 26.
Yes, read. What is the explanation?
Yes.
Why you came to the court then? Immediately, 2 days after the samples were collected. अगर विशिष्ट हिंदी में कहा जाए तो चोर की दाढ़ी में तिनका वाला केस है. Yes.
Para 15, my lord, page 42.
Para 15. Yes, please.
That the petitioner has submitted some sample with a representation.
Some sample. So you yourself are very conscious that you have not supplied the complete set of samples.
No, I have never withhold that, my lord.
So
Therefore, to say
you
that
should
I'm
have
getting-
gone to the authorities.
My lord, on other ground, if my writ petition is dismissed, that will be, but on the ground of suppression, my lord. Petitioner
that is why we
submitted
are offering you-
some-sample representation dated stating that authorities are.
Chaudhary,
sample-
that is why we are giving you that option that on account of your couched submission, we can give you that benefit of doubt saying that the cost will be made easy and participate in the
Lordship will
process.
have this matter on Monday. Let me have the instruction from the
Very
client.
well.
Or repetition.
Monday.
Daily list. Daily list top of the matters. Item 1 and 2.
My lord, in this case, we have challenged the decision of the Airport Authority of India to let out. the-
Is it not now too late in the day? This decision
No,
is
my lord,
across the
there
country.
is an inter-
We would like to ask you,
Yes.
this decision has been taken not only for Guwahati. There are large number of more airports wherein this decision has been taken. Has this decision been challenged in any other high court? You would like to know.
It was challenged in Kerala High Court.
What happened?
Outcome to give.
The petitions have been dismissed, my lord, and one of the petitioner has carried it to apex court, my lord.
Okay,
That also, my lord, has been dismissed, my lord. I have
that
not-
has been dismissed.
And
Let us see the order.
Yes, yes. My lord.
Well, I do not know whether the facts are same.
We don't know. Let us,
If
let us,
Lordship would kindly have airport, I'll just draw your lordship into one provision, minor.
just hold on, sir. If an analogous controversy has been decided right up to the Supreme
Don't know
Court,
what is the ground.
let us see,
Yes.
let's see the judgment. Or if
My
you
lord,
want,
lordship would recollect that BPCL privatization was interfered by the Supreme Court because there was a violation of the statute.
this is
Same
not
is the
strict
case here.
sense of- This is not strict sense of privatization, Mr. Chaudhary. This is just operations being provided to a private.
No, my lord,
service.
it is a violation of the statute.
See, let's see. Would you like to have a look at the
Of course, I
judgment?
do not have.
Then you all right, you have a look at the judgment.
It is Kerala.
Kerala.
Then counsel, your good name, please.
R Dubey, my lord.
R. Gohin
R Dubey.
Dubey, appearing for
2, 3 and 4 years.
respondents numbers 2, 3 and 4 has drawn the court's attention to the judgment rendered by Kerala High Court. Judgment dated 19th October 2020 rendered by Kerala High Court, and is urges that an identical controversy which is raised in the present litigation was decided in favor of the Airport Authority of India, and that the SLP preferred against the said judgment has been dismissed by Honorable the Supreme Court. Mr. Ken Chaudhary, General Counsel, representing the petitioner in PIL number 11/19, and Mr. Mahanta, representing the petitioner in WPC number 4627/21, pray for and are granted short opportunity to complete their instructions with a reference. Complete the instructions in light of the above development. Notify up to 4 weeks.
Item number 2, notices have to be issued.
We'll see whether it is a requirement to issue the notice or not. Have a look at the judgment. You have provided copy.
Yes, yes, my lord.
Okay.
Both.
IFSC, I have seen it, my lord, the ground, anyway.
Satisfy us that the grounds were not common.
In
Yes,
fact, all these issues that have been raised in the writ petition, my lord, I have gone. to
You
the
get
judgment.
the copy of the writ petition also, if
But
possible,
in fact,
and the SLP.
My lord, there are 9 grounds that has been taken in the, my lord, I'll take.
More important would be the SLP.
Yes, yes. my lord.
If the SLP, the same grounds have been taken, then
Of course.
the things are closed by that judgment, covered by that judgment.
Alteration of conditions of service.
What happened, Mr. Manta?
Item 2 is different, madam, because
We know that the condition of service, we have
But
seen
in
that.
fact, that issue has also been dealt with in the judgment, my lord.
I'll read it.
I will.
There were
My lord,
series
there
of
is,
writ
anyway, my lord, I'll address your lordships on the next date, whether that has been, my lord, so far as the airports are concerned, the one is air side, one is city side. Now, air side, I mean, that cannot be given to anybody.
The
In
strip,
fact, section 12A of the Airport Authorities Act. My
by
lord.
this decision, the air side has also been.
Yes, my lord, other than air traffic control and my lord, navigation and surveillance, everything has been given. And the section 12 proviso says you can give, but you cannot give the function of the authority under section 12.
Yeah,
That's why, my lord, this honorable gave an order whereby you may proceed, that will be subject to the outcome of the case.
Oh,
In
that's
fact, a
fine.
lot of argument was gone into at
No,
that
no, we
stage.
understand, we understand. That is a valid argument you are raising.
Yes,
They had said that otherwise also doesn't appeal,
yes.
basically.
Ah.
That is a very sensitive part of the
Yes.
operations which has to be
City
with the,
side, you won't give to anybody. That you can
that
give.
is a commercial part of
Ah,
it.
commercial.
Yes.
And
Let's
moreover,
see.
Guwahati is a, my lord, it's it's an airport for the, for
Military,
defense also.
defense, yes,
So to some aspect,
yes.
significant different aspects are there.
Does the state not have any stake in this?
No,
Mr. Advocate General,
no.
state has no say in this matter.
Because it is under airport office.
Airport authority, all right. And the land is also of the defense.
Yes.
Yes.
Right.
But if I permitted to indicate, Lord, in the Kerala judgment, Lord, the state was also a party, but they had challenged it because they had also bidded with one KSI PC.
Oh, yes, Kerala
Yeah, the
state
land
also
which was
bid.
also there.
Kerala state was probably in support of the petitioners.
No,
Yes,
they
in
were
fact, they were one
they
of the
were writ
petitioner.
petitioners, madam. There is an additional ground.
Yeah. Let's just have a look at the judgment. If these aspects have been dealt with,
Yes, yes. I'll
how you
cooperate,
distinguish that, you will have to satisfy us.
Item number 3 and 4.
Lordship, I pray for some accommodation, Lordship. Mr. Ansida, Senior Counsel, is not keeping well today. Can it be posted in the next week, any day, Lordship?
My lord, the only point here, my lord, that after the recovery certificate issued, it will be governed by the Bengal Public Demand Recovery Act. And interest, my lord, payable as per that act. And we have paid the interest as per the Recovery Act, my lord. Now they wanted to impose more interest, my lord.
The council, MS, your good name, madam?
M. Devi, Lordship.
M. Devi submits that arguing counsel, Mr.
NC Das. NC Das.
NC Das is not available today and seeks short accommodation.
Lordship.
Madam,
Can
it is
it be
11:15, we are running out of cases. Yes, sad state of affairs. Re-notify on. When will he be back?
16th August, my lord.
16th.
16 public.
My junior is coming from Jorhat, my lord, so that is why I like.
Okay. 16.
Obliged, Lordship.
Item number 5.
Item number 5, Mr. D. Nath is appearing. He is on legs.
What is the matter?
Vote number 3.
What is the matter, gentlemen?
Lordship.
He's there, Lordship.
Terminated by the authority.
Termination. And labor court? Labor court you have gone or not?
Lordship, I have gone the reference case.
Yes. The labor court has also affirmed.
Also affirmed, Lordship.
There is a concurrent finding of fact.
File the read petition and the.
Then these are then concurrent findings of fact, sir. What is the issue of law involved? Plain and simple. Nothing beyond that in a writ appeal.
Madam, maybe for time being, Lordship, my senior is engaged in another policy. On time being.
These are matters of labor. If you're not really interested, then what is the point of filing this writ appeal? It's pending since 2019.
Lordship. But
Mr. Saikia, we will request you, is there a whole bunch of state litigation? We are trying to, requesting the bar to bail us out. 11:15, we are pleading that someone argue the matters. How the things will go on? What should the court do? The sad state of affairs. At the first instance, the members of the bar requested old hearings are not being taken up. Now, each and every file which is pending in the old hearing category, they have been listed in the courts. You are not ready to do it.
no, Lordship, only time being, Lordship.
Timing just now. All right, pass over. He'll come in 5 minutes.
Item number 6.
Wares and wants. Yes. Let's come on.
Lord, I am the owner of a private gym. So my part is virtually taken care of it by the interim order. The court wanted to know further what
Private?
steps-
You are the owner of a private
private gym,
jeep,
gym.
gym, or is that matter?
Yes.
Compensation was awarded.
Yes, madam. So far, our part is concerned, it is the court has stated, but
Yeah.
the court wanted further to know what the government of Assam has.
Government has done.
done.
Disabilities, persons with disabilities.
Yes, madam. And they have filed a big affidavit. And the petitioner.
Who is representing the petitioner? You are there. You are ready?
I'm ready, Your Lordship. Unfortunately, the affidavit has not been served on me. Your Lordship. I've just heard that this affidavit has been filed.
I'll,
A copy has. not been
I have served the appeal and I'll give a copy. I'll give it.
I'm.
The petitioner is the person affected in this case.
Well, directions is that otherwise pay at
So
24.
the direction to pay compensation so far as state is concerned,
It is paid.
they are not aggrieved
It
by that.
It is paid. In affidavit, we have said. It is
So what other than that, what is the responsibility?
other directions kindly come to page 61.
Yes,
Learned single just directed, malab, that being the position and considering the issue in its entirety, court is of the view that the following directions may meet the ends of justice. Number one, all the officers and employees serving in the social welfare department, government of Assam, including the directorate and at the grassroots level, should undergo training and awareness program to sensitize them
Madam
about the
Chaudhary,
rights.
so far as the private appellant is concerned, they have given out in affidavit that they did whatever possible was there.
Lordship.
Why they have been penalized? We don't see any justification for imposing cost on them.
Lordships, if I may just address it.
Yes, please. State authorities is all right, what they have already come out with a complete comprehensive affidavit. But
And my lord, when the old act was old act was there, the two private bodies were not included, but in the new act of 2006, now private as well. So
this is
after
an incident
2000
post 2006.
This is prior to the
The incident is prior to 2006.
2006.
2016, Your Lordship.
16.
My Lord.
16.
2016.
This incident is of,
2011, Your Lordship.
so that would be an argument that private bodies were not
I-
covered in the ambit of the act.
But
That was
Your
the
Lordship,
argument,
but-
precisely.
But then, Your Lordship, if I may just pray before Your Lordships, that the insofar as Article 12 is concerned, how it has developed over a period of time, that is something which even my learned friend is aware of.
We
And the
understand.
Honorable Apex Court has held at various occasions that in a social welfare state, a private entity cannot hide its
Practically,
head
practically
in
do
the
not
sand.
find any fault on part of the private entity, private person.
Lordships, it was only perhaps the attitude. That is the only thing, Your Lordship. Lordship, this
So
is,
just for the mental satisfaction,
no, it is not.
the cost is to be awarded or what?
Lordships, a cost has not even been awarded to me. It is not a cost imposed on
Maybe.
me. It is a
We
cost
understand.
imposed on to be given to some NGO. And my
That,
learned friend is not
perhaps,
agreed.
you know what happens is that becomes stigmatic. So we perhaps can modify, say that they have volunteered to offer that amount. That's a different thing. But
Lordships,
imposing cost becomes a stigma.
Lordships.
That is the problem.
Lordships, the point of the matter is that in the learned single judge's judgment, there is a stigmatic observation against them. They're not agreed by that. The only prayer in the instant writ appeal is insofar as the compensation awarded against them is concerned. They are not concerned about the
So
stigmatic.
they would be arguing on the ground that they were not covered by the act when the
They-
incident took place.
Lordship, there's not even a whisper about that particular stigmatic observation by the learned single judge in the
They
instant
they
appeal.
may not be bothered,
Lordships.
but ultimately if the cost is made easy or the cost part is removed,
Lordships.
their role is over.
That is correct, Your Lordship.
So
The
then-
point of the matter is, Lordship, that how was the appellant, the respondent before Your Lordships, how was he treated at that instant
So
point
for
of
that,
time?
you would have to go and file a suit for
Correct.
damages.
Perhaps, Your Lordships.
Then
Now, Lordships, but the point of the matter is
but
that.
it's your allegation, they have countered it. Now, whether this court is going to take evidence,
Lordships,
that is the
not
question
evidence
is,
per
then
se, but perhaps
that
considering
becomes a
the fact
disputed-
that it is a matter with.
that becomes a, yes, we understand that we have to deal with this category of persons more
A
sensitively.
little more
But
sensitive. That is
when the
only-
matter purely comes out
Not-
on a platform where we have to appreciate evidence, whether writ jurisdiction is the correct jurisdiction to do so.
Lordships, it is not a matter of, it was only a representation which I had made and the answer which they had given to my representation. That is the only evidence per se. If your Lordships are looking into the evidence part of it, that is only one of my representation and the reply which they had given to
Reply.
my
So
to my
then
representation.
how,
Now-
how to test the veracity of the two stands?
Correct.
What is the mode for this court
Perhaps-
finding?
No, your Lordships are perhaps absolutely correct insofar as the suit part is concerned, that perhaps I need to go and file a suit there. The matter at that point of time was with regard to the compensation and how they. were-
Compensation, how can compensation has not even been awarded. So your prayer for compensation has not been accepted.
No,
So perhaps you can use these stigmatic findings to file a suit.
perhaps, your
That would also now be time barred.
lordships, considering the fact that we have been here before this honorable court, perhaps it might not be, or some court might. do some kind of leverage.
When was the order passed?
It was passed in 2019, your lordships.
19, so 3 years have passed even from that.
Yes. yes.
So you
But there was a stay
take the cause of
petition.
action from any angle, from the
But
date of the incident,
the-
the date of the order, how the litigation, you are not carrying it now. They have come in appeal.
Correct.
Maybe we will not comment on that. If you're desirous of suing the respondent for the appellant for compensation, will not perhaps.
My only concern was the manner and method in which the respondent number 6 or the appellant before your lordships had
That's what
conducted
we are
their
saying.
entire this thing.
That's what we are
The
saying, that
conduct of the
they have controverted your submissions. What is the mode for the court to evaluate? That's what
Then
we
in that
find
case,
that
your
there is
lordship-
nothing.
lordships. In that case, your lordships will kindly see what are the other directions which were issued by the learned single judge.
Other directions are to the
lordships
state.
Lordships
state.
against the state.
The
yes.
state has filed an affidavit saying that we have complied.
Lordships, if I may just be allowed to at least
All right,
have a look at the affidavit.
Mr. Nath shall provide a copy of the affidavit filed on behalf of the state to the learned counsel for respondent number 1. Re-notify after 2 weeks.
Deeply obliged.
Deeply.
Item number 7 and 8.
Yes, please. What about, sir?
Lordship.
Hmm?
List of dates.
List of dates?
That other matter is very simple.
Hmm.
Matter
If it
relates
is
to-
not simple, you will make it simple. We are sure, sir. Yes.
I thought that matter relates.
Ms.
to-
Saikia, Mr. Advocate General, we'll need your assistance in the criminal matters for a while. Please be here when the matters are called out after this one. Yes. Yes.
But the matter relates to appointment to the post of LDA in a provincialized madrasa. What I find out that the procedure for selection is very simple.
Hmm.
That candidate marks which he obtained in SSLC examination, marks he obtained in the 1-year computer certificate examination, and Viva marks obtained the Viva.
Just a moment, sir. You are litigating against respondent number 1.
Lordship, yes.
Who is representing him? Mr. S. Ahmed, Miss M. Gogoi. That's right. No, it's Mr. H.R.A. Chaudhary. Can you call him, please? There are few names. What is the writ petition about? There is a writ petition also. What is that writ petition about?
For that petition, I have filed it for rectification of my, in the marks shown in the tabulation.
There's a division bench writ petition or a single bench?
Single bench, Lordship.
So that has been decided.
No,
Why is it shown in the columns?
it is not decided, my lord. That was another repetition filed.
Which has
after-
been tagged here.
After the,
Lordship.
it has been tagged in the repetition. What had happened, my lord?
You tell us.
Proprietary based.
Hmm.
A selection for an LDA appointment in a madrasa,
Hmm.
provincialized madrasa. Selection took place, there was a format given by the government as to how the committee is to be formed.
Hmm.
Writ petition, the private respondent in the writ petition came to be appointed.
Hmm.
Writ petitioner challenges saying that there are 2 select lists.
Hmm.
By the selection committee, 2 select lists was given, 7 numbers of members, 4 members gave a select list recommending one person, 3 members gave a select list recommending another person.
Okay.
Then Madrasa board decided to take on the select list, which was signed by the nominee of, by the representative of the director of Madrasa Education.
Okay.
Learned single judge found 2 select lists, the quorum not having been completed, entire set aside, go for a fresh selection.
Okay.
That is under challenge now.
What is wrong in it? And the respondent continues to serve.
No, her selection was set aside.
I was appointed, I'm serving, Lordship. That I was appointed, that has been challenged by the respondent number 1. But
You were appointed.
Lordship, I was appointed.
And
So,
post decision of the single bench, what is the status? There is a stay operating in
I'm
your favor.
continuing because
You are
pending to
continuing.
appeal, Lordship.
All right. You are appearing for the private respondent, sir? Ready? Okay, all right. Proceed. Let's see the judgment then.
Page 96 onwards.
The evaluation process has been found to be flawed.
Yes. Because prior to that, if Lordship would have the notification by which the committee is formed, that would have some. That Lordship.
Very simple that the dispute is that I got 84% in my computer examination. When the tabulation, I'm shown to have got Lordship 60%. As a result, my position has come down. When I filed a representation before the director, showing that error had taken place in tabulations. He calculated my marks and found me, I was topping in the list, so I was ordered to be appointed. That's the only thing, Lordship.
The director appointed, directed.
Director, list prepared by the director. My name is.
Directorate of the Education Department or Madrasa Board.
Then it was the Madrasa, but now it has come in.
Where is that order? Where is that order?
The writ petition I have that I filed separately, Lordship, there I've annexed the representation which I've submitted to the director at page 47 of the writ petition, Lordship.
What was the mode of selection? What was the process of evaluation?
It is there in that notification, Lordship, at page 34.
Only on marks secured in the qualifying examination.
Viva was and computer test.
Viva was saying computer
Test.
computer test. Okay.
SSLC marks plus marks obtained in the computer plus Viva was.
So what is the role of the selection committee? Viva was saying
Viva was and then they calculate the marks.
tabulation.
Lordship,
Yeah,
to prepare the tabulations. But in a tabulation, my mark is wrongly shown.
Okay, so your writ petition is to correct the tabulation.
Lordship, that subsequent writ petition I have filed, to correct that, rectify that my marks in a tabulation.
What is your stand in the writ petition? If we decide the writ petition in his favor, then nothing is left.
If the tabulation is even corrected, this selection committee, whatever marks they give in the Viva was, when the members are divided, not giving us a complete solution. If Lordship will have page 34, serial number 3 for a moment.
Just okay.
The notification. Serial number 3.
Huh.
The selection shall not be valid in the absence of at least one member, either from the director of Madrasa Education or the managing committee governing body SMDC of the concerned institution. The two select lists, in one, the nominee of the director was absent, and in the other, the secretary of the SMC is absent.
So both were invalid.
Both were difficult. So at that point of time, the director of Madrasa Education had given the.
Irrespective of the writ petition, even if we direct evaluation, but the selection committee not having been,
they are not agreeing.
Constitution not being in accordance with law.
And
Selection
they are not agreeing to the marks being given in the Viva.
But now what would be the situation now? Whether this situation prevails now? Can there be a selection in the same light now?
It will have to be now done by the director of secondary education. If it is done, it is done by the director of secondary education. She continues till the day the selection is held. If she is holding the field, let us not ask. They may participate, both may participate.
Both of you participate. Let there be a proper selection process as per the prevailing rules now.
I'll continue, Lordship.
But till then, we'll allow you to continue. What do you say? Yes.
Only part matter is the age limit, because young.
Age relaxation.
In the special circumstances, since they were under litigation.
We will observe this. And the evaluation writ petition also will be disposed of then.
Lordship.
Okay, very well. We'll decide it accordingly. Director secondary education.
Secondary education would be done.
Under which rules?
2018 rules.
But again, the process will have to be opened, Mr. Mazumdar. Can it be between two candidates?
Not the two candidates. Anybody who had applied on that day.
All who had applied.
All who had applied will get access.
So then, but then all will have become overage. All applying candidates who applied.
With that.
What is the direction of the single judge? Let's see whether that takes care of the things. But the single judge has directed the other side to be the other candidate to be appointed.
Page 99, Learned senior judge
Fresh
objected.
advertisement. That is what the direction is. So well, that order stands. Now the only thing is to give you age relaxation.
Yes.
Until the fresh selection is made,
Lord.
you continue. All right.
Obligation.
All right. If third candidate comes in, then there will be another round of litigation. What a mess this is. Anyhow. Dispose of. This is item number 7 and 8. Okay. Chali.
Oblige.
Okay. Same situation. Yes.
Daily list for
Saikya, we had retained you. Yesterday, we were hearing a matter criminal appeal. And we were told that there was hardly any process of sending the forensic, the samples, the case articles to the forensic science laboratory. There's hardly anything. So what is the status in the state? In Rajasthan, by judicial orders, we have ensured there are forensic science laboratories in place at every divisional headquarters and a smaller version in every district. So now the samples, earlier the samples used to take 2 years, 3 years for being tested. Now it is done in 2 months. So what is the status in the state?
I'll obtain that instructions
If
because we had only one.
Madam Jahan pointed it out to us yesterday.
So I'll take the up-to-date instructions because we have taken a lot of steps regard to overcome these difficulties last 2 years.
Because this is a very, very important part of criminal investigation.
I'll address to.
If you don't have the FSLs, the DNA testing facility, many important investigations fail on this count only.
For DNA, we are taking help of either Chandigarh or Hyderabad.
Hyderabad.
Yes.
In Rajasthan, it is being done in Jaipur now.
Other parts, Lordship, because initially it was one. Now there are some developments in this regard. And
Can
we
you
have
give us a
also
brief
recently
note?
started the
Can you
work
give
of
us a brief note?
University
Maybe in
also.
one of these matters,
Yes, Lord.
we'll make certain observations which may help the state
Lordship.
to move forward. We'll get that order from Rajasthan also,
Lordship.
wherein by a judicial order, the laboratories have been established in the
We are
districts.
aware of this lacuna in our system, Lordship. I'll address.
That is a serious compromise on criminal investigation.
Lordship, because ultimately nowadays all this scientific evidence-
investigation is a foolproof way.
Yes, Lordship.
And
In certain
in
cases, it is sent, not, in certain cases, it is sent. We have the forensic science laboratory, Kairi Para.
many a times you need corroboration.
Yes.
So that corroboration, where does it come from? Yesterday, what you were saying,
Yes.
samples were not even sent.
Not even sent. Today, there is a matter, second matter of the criminal appeal where the samples were sent and a report came that it is of human blood and the blood group was B positive. But without matching it with the accused or the deceased, they did not take the blood. And no purpose will be solved.
So then that second part is training of your prosecutors and investigators together.
Yes.
That is essential.
That is, we are also going to change the whole system. We are already the advertisement is issued regarding having the prosecution directorate.
Now that is essential.
That is already, we
It's
have
already
brought the
done.
law, the advertisement is out. And now we are going to recruit the public prosecutors and assistant public prosecutors for all districts.
That's good. Okay.
A lot of things are changing, Lordship. We are
That's
aware
what
of-
we wanted to find out. That
That
was the
is why
anxiety.
I'd like to address maybe
So
on Monday or.
Monday,
Tuesday.
please.
Lord,
Yes,
I'll
and
address.
we are listing criminal matters.
Lord.
In any of those matters, you can please address.
Monday or Wednesday, Monday I'll not be there. So Monday or Wednesday.
Learned Advocate General will address. Matters will be listed. Any of these
I'll not make any submission on the matter. on this
He'll
general-
not make any submission on merits.
No.
We are on principle of this,
Yes.
or the aspect of this forensic
Lord.
investigation.
Yes.
Deeply obliged, Lord.
Thank you. All right. All right. What are the matters about today?
item number 22, Lordship.
In this matter, what had happened is that there were very less evidence. So Honorable Division Bench had sent for examination of
319.
additional evidence.
319.
319.
Yes.
But then there is a report. In fact, there are 3 reports. First report said that they could not serve the parties. Second, they had served, they had examined few
The
of them.
319 process has not been completed as yet.
No, Lordship, this has not been completed. The last communication that had come from the session judge was of August 22, where it is said that one witness had expired Two witnesses were examined. One, it could not be, notices could not be served. Lordship, there is the report from the session judge.
Which is the
Dated-
order whereby we directed recording of additional evidence?
This is of 2021.
But
This
then
is
in 20, somewhere in April 22,
on 19. This was by order dated 16/9/2019.
16/9.
2019.
So the record is not here.
Record is here.
But if the record is here, how the session judge will record evidence?
I think there was a supplementary.
If the record is here, madam,
Uh-huh.
how will the trial court record evidence?
Registry shall send back the LCR. In fact, that is what was directed on the last occasion. With a copy of this order to the learned session judge. After completing of the recording of evidence, perhaps it was sent back.
What latest information you are having?
This is the information dated 19/4/22. No, 10/8/22.
Also, thereafter, there is a report of 30th November.
But I think the report of the session judge was of 10th of August.
Give the original record, we'll find out.
Lordship.
Copy of the order dated so and so. This is it. What is the case? What is the evidence?
Here, what had happened, the driver was found dead.
A truck driver.
Yes, inside the truck.
And what evidence did you record? What evidence did you present for convicting him?
And the circumstantial evidences are there, Lordship. In fact,
Who is the accused? Is the accused the
handyman.
Kalasi of the truck?
The accused is the handyman of the truck. and the-
Kalasi, that's right.
There is no
And
evidence from that.
No evidence.
Yes, Lordship. 7 witnesses was examined, Lordship, including doctor and IO, Lordship. But nobody has implicated me, Lordship. That I am the handyman of this truck. Now 391, Lordship, to record additional evidence, where the material evidence on record does not implicate me. Considering the provision of 391, if we convict me, Lordship, after it is.
We are not expressing any opinion as yet.
Yes. Because from my possession, Lordship, some currency notes was recovered
Okay.
after one day of the occurrence from Sipsagar police, Lordship. But the FSL reports stated that the note contained the blood group of human blood and it is contained a blood B positive. So disease blood group and
Just a moment. Ramchand still not examined. What was Ramchand deposing during investigation?
Ramchand was not a witness, even if
Not
you
a cited
charge it.
witness.
Not a charge sheeted witness, yes. In fact, the police personnel said that we had not made him witness.
No clue found. They do not know such possession. Have been completed. Record of the case is returned back.
Acha.
Yes. That is 4/8/22, the report.
4/8/22.
Yes. So they have completed the process and the record has been received. Then what is to be done, madam? We'll proceed with the appeal.
Not check.
All right, let us see. What is the evidence? Let's see the judgment then.
Lordship, may I read the evidence, FIR on the page
FIR will be against unknown man
page 4, yes.
who has said that you were the Kalasi on the truck.
Nobody said, Lordship.
And
Only the IO stated.
as per you,
Yes.
what is the best evidence available with the prosecution?
Nothing, Lordship.
Nothing.
Nothing. May I read page 8, Lordship?
Can we read the judgment for a moment? Judgment is at page number?
60, para 16, Lordship,
What are the circumstances
against me.
against you? What does the learned session judge say?
This is at paragraph 22 of the judgment, page 34.
And he's in custody from when?
He's in custody from.
Madam, make one practice
No,
in every criminal appeal, whenever
Mhm.
you are receive the copy of the appeal,
Yes.
get a custodial certificate. We'll direct the office to do that.
Yes. This was not our practice actually.
We'll get it immediately.
Gotcha.
We'll pass an order today. Custody certificate has to be there.
May I read, Lordship?
Just hold on, please. Just give us 2 minutes. Para 16.
Yes, Lordship. Para 16.
In fact, it is reflected in the cause list. He was inside for 6 years.
This approach, I'm I'm sorry to say, the session judges say, investigation officer has specifically narrated, it was found that the accused was handyman. I find that this aspect has not been denied by the defense side. The cardinal principle that the prosecution has to stand on its own legs
Yes.
seems to be alien to the system in Assam.
Mhm.
This is unrebutted from the cross-examination.
That cannot.
Oh, the IO was not the person to say that he was the handyman.
Mm.
They had to be the owner of the truck or the operator of the transport company.
Mm.
Ridiculous. Currency notes. When were the currency notes seized? Let us see. What was the link evidence? What is the date of the arrest? All right,
Date of the-
PW7, let us
yes.
see. Where is the Caesar memo, gentlemen?
Yes, Lordship.
Caesar memo of currency
Page
note
38.
is 38.
Page 55.
38 will start.
38 is the truck.
That is the truck. Where is the
yes.
Caesar memo of the currency
Caesar
notes?
Is after that 40,
Page, starting from page 40, Lordship.
40,
100 rupees note, 108 numbers.
This is seized in pursuance of what?
This is seized by the Sibsagar police in pursuance of, after he was arrested
Just
on 19.
in pursuance of his arrest. What is the date of the incident?
The date of the incident was 18th February 2008.
So on the next day,
Next day.
these notes were
morning.
recovered.
Hmm.
100 rupees, 50 rupees, 20 rupees.
Yes.
Blood stained.
Yeah.
Nokia mobile. Right now, where is the FSL report?
FSL report is at page 55.
55. Who says about the safe custody of the samples? Who is your witness?
This.
What happened to the notes after they were seized?
Uh,
Where were they
yes.
placed?
Because the Caesar witnesses, one was examined Ashok Sharma, PW2,
Madam,
where it is kept.
linked evidence regarding safe custody of the samples from the date of Caesar till they reach the FSL. That is essential.
This has to be kept in the Malkhana and has to be.
Who is the witness?
but,
Is the Malkhana in charge the
uh,
witness?
The police had stated, the police, PW2, no, PW 4.
But iron range,
Uh,
multicolored
yes.
woolen blanket. And C. A, B, C, so and so. Where was the blanket seized from?
From the truck.
From the truck. So the blood group of the deceased would be on the blanket, but why not his clothes? Why his clothes were not sent?
Clothes, there is nothing. to
Blanket
clothes
can have
were
blood,
seized.
blood group of anyone for that matter.
Blanket and the range.
Wrench was seized lying near the truck. So how
Inside.
does it connect the accused?
Because it was a blunt, it was the head injury was there and it was considered, that was the murder weapon.
So page 21, one of the serial witnesses,
21.
page 21.
Let's see. We'll read the evidence of the IU.
Yes,
To become
IU.
clear.
Page number 16.
On 19 to 2008, I was working as a attached officer at Moran PS on that day at about 8:15 a.m. The
You're
OC
reading page 21 of the paper book.
Yes, paper book.
That is PW 7.
Yes,
So 16.
this is a serial witness.
So that is not PW 7. Which is the prosecution witness number?
Yes,
PW
7.
2 or 7. 7 is the Dipankar Fukon.
Dipankar Fukon, yes, Lordship. He is one of the serial witness, Lordship. But he stated, Lordship, one day while I went to the PS, I put my signature in the PS itself on being asked by police. Then why serial has been made properly or not, Lordship?
Who is the IU?
IO PW
PW 4, page 16.
Page 16.
He is the
In
best
fact,
witness.
There are two PW 4s, but 16 is the other.
We will just see that.
On 19 to 2008, I was working as an attached officer at Moran PS. On that day at about 8:15 a.m., the OC received an information over phone from Ashok Sharma that one dead body was found in the abandoned truck in Jalong area, which was parked near his hotel. On receipt of the information, entry was made in the general diary by number 400 dated 19 to 2008. After making the entry, OC entrusted me to make an preliminary inquiry. Accordingly, I proceeded towards the place along with my staff. On the place of occurrence, one male dead body was found lying in an abandoned truck being registration number WB so and so, Lordship, 2527. Thereafter, inquest over the dead body was done and it was sent for postmortem.
Why was the FIR not registered immediately after recovering the dead body? The fabrication is there.
Yes.
Registered the FIR after arresting the accused on the next day.
FIR was on 20th of February.
So the body was recovered on 19, 8:15 a.m.
Yes.
You arrest the accused, make the recoveries and then register the FIR. Which is this procedure?
Yes, GD entry was made. In fact, GD entry can be considered.
Where
as
is the
the
GD
FIR.
entry? Where is the GD entry?
GD entry is again not exhibited. It's there in the record. But
Extremely sorry state of
very,
affairs.
of course, these things are there. Otherwise, GD entry will be the first information here.
Where is the arrest memo? What is the arrest memo exhibit?
Arrest memo not exhibited. Here it is like that. Just check it's. I think it's ASB.
Hmm. Avtar Singh gave the FIR. 28th February. After the accused was arrested. Avtar Singh has not been examined, he has been examined,
Examine lordship,
not supported.
not supported. PW1.
No. But then you were supposed to record the report, register the FIR immediately after the dead body was found.
Yes.
Hmm. So
Dead body was actually, this FIR was lodged by the owner.
need not have been.
Yes.
Once the
He
police
reached- he
police
reached-
comes to know, he reached on the next day. Once the police comes to know that there is a dead body, it's a case of homicide.
They were waiting for
FIR had to be
somebody.
registered against an unknown person. Investigation was to be carried out thereafter.
They were waiting for someone to come. In fact, this Avtar Singh reached late and thereafter they registered.
Then
This is what-
his statement would have been a statement under 161.
Yes.
All right, we'll pass the judgment.
These circumstances are very, of course, less. The truck was found and the next day, night patrol party had arrested. Currency notes were found. And
Where are the persons who apprehended the accused? Who are the witnesses?
of course, they could not, the IO was later on examined under 319.
He has been examined.
Huh. The
PW?
IO, after this,
Then what is the
but
name
then
of the IO?
the court wanted a GD entry and GD entry could not be produced. That
Even
subject-
after 319?
after 319. What I could read from the order of the section.
CW2.
He is the Sibsagar police personnel.
The original statements. Avtar Singh. Avtar Singh has been recalled or what? Avtar Singh was examined initially.
PW1.
Then he has been recalled on 319.
Maybe.
But that was not required.
Yes, Avtar Singh, PW1 taken on 24th February 22. He has been examined for the purpose of finding out who is Ramchandra.
Ramchand was the owner of the transporter company.
He is not, he could not be traced out.
Yes. He could not be traced out. But IO, it seems,
Sunita Agarwala, GPA.
that was done by video conferencing.
It's okay. Then it is Radhanath Barwa. Yes, he is the. Not been able to trace out the GD entry.
GD entry.
What remains? Okay.
By seeing the sketch map, I could find that the truck was heading towards Sibsagar, was stranded towards Sibsagar. And Sibsagar, this person was arrested.
All right,
Small
pass
link.
the judgment.
Small link.
Okay. The appeal is allowed.
Not.
Okay. Very well.
Apply those.
Oh, absolutely.
My lord, we have spoken to our client, my lord. Lordship will allow, direct them to proceed with the tender. Only thing is cost part, lordship will interfere.
What do you say? Cost?
Nothing. Cost is between my lord and I have nothing to say.
So like,
Malad, there are one thing, what I was instructed, there are three options given in the 145. My lord will maintain that, let the school authorities or the government authorities take.
yeah,
that
we
decision.
will not, the options which the learned single judge has
Let that be
set
there.
out, let them be worked out by the authorities,
Lordship.
right? Okay, disposed of.
Much obliged. That direction, my lord.
In case of tender, I'll be at liberty to participate.
Yes, of course.
My lord, page 145, D,
145.
D.
Okay.
Lordship.
Give a brief joint judgment. Agreed judgment. The mediation bill has come. This is mediation to the ultimate level of the ultimate level.
Much obliged, your lordship.
Deep level.
Item number 23.
Let the state council also be aware, as a easier. Okay. Item number 23.
Here,
What is it,
of course,
madam?
the husband killed the wife. Better case than before.
106.
Yes, one.
You rely upon where did the incident take place?
Inside the house, but he had given an explanation. It seems to be incorrect.
Okay. No
So
one there.
false explanation cannot become a link, but it can lend credence to other
None
circumstances.
present for the plain list up to 1 week.
Yes. The council is not here, I think, but.
That's why we are adjourning it by a week.
Gotcha.
Mm.
Item number 25.
This is the matter, if your lordship might recall, the state was required to file an affidavit.
Custodial
regarding
debts.
Custodial debts, your lordship.
Yes, Nath
They-
was coming.
No.
Ms. Saike.
Psyche
Yes.
appears. Lordship, they filed an affidavit just now. It's an application, it's an affidavit where a reply will certainly be required from my side. Perhaps just a week's time, your lordships.
No objection from.
Affidavit has been filed by the state in pursuance of the direction given by us on the last day.
21st, yes.
Affidavit on behalf of the state has been filed today.
Additional affidavit, Lord.
Additional affidavit. Related Council MS RS Chaudhary, representing the petitioner. Praise for and is granted 3 weeks to file affidavit in
Lordships,
reply.
Only a week's time. Lordship.
2 weeks time.
Lordships, could I have a date subject to your lordship's convenience?
I'll re-notify on
21st?
25th August.
I'll be here. Okay. Deeply obliged.
Obliged.
Item 28 and 29.
No one. That is lordship. Lordship, Mr. Ayavia is on lag lordship. The lordship.
Council, Mr. Boyan is reportedly busy in some other. What is the matter?
It is regarding, we are disqualifying the M debt and not equating with the normal state debt, Lordship.
Okay.
There's a huge structural difference.
Okay. List after 2 weeks. SEBI. We are presenting SEBI, Mr. Saike. Next case, we are adjourned.
Yes.
The council is not there. Next matter.
Item number 30.
You are there for the appellant, SEBI.
I'm for the appellate.
Yeah.
So in this case, Lordship, some records have come from Bombay last night, Lordship.
Okay.
I have to go through it because.
What is the matter about?
The matter is regarding whether 2 different notices are required or 1 notice is sufficient to start a penalty proceedings.
Okay.
So for that, the opinion has to be formed, Lordship. That record we have to see whether that proper opinion was formed by us or not.
Senior Advocate Saike, appearing for the appellant, submit that he has received the records recently here and before and need some time to go over this, go through the records. Go through the same list on list on
25th.
12th September. Okay.
Lordship, highly obliged.
Yes, please. Deep. But something has to be done about investigation, Mr. Saike. It's a very sorry state of affairs.
That, Lordship, we are in the process.
We know Honorable
transition is
CM
going
is very intent on that, but
Yes.
the system is lagging behind. You need to harness some experts from the other areas.
No, we have brought one expert also.
Okay.
Day before yesterday, he went back again because of his family's problem. Mr. Krishna was here. So-
We know he has
Yeah.
gone.
He has
Your
got-
DGP is a well-meaning man, but
now,
how many things can he take care of?
yes, Lordship. Now, we have, last week, we had a SP level meeting in Bongaigaon. About 1 year back, the SP level meeting was held in Duliajan in January 2022.
We know.
There's a huge difference of improvement. We have the data. So it will take little bit more time.
That's all right.
But it is in the
Transition.
right path now.
All right. Okay. Very well.
But with lordship's direction also, it can be further improved, lordship.
We will try and.
Lordship,
Yes.
highly obliged. Lord.
Pass over matter, item 5.
I'm extremely sorry, Your Lordship, I got stuck up in.
No, it's okay.
We have come against the concurrent finding, Your Lordship,
So
of the.
what is the scope of
Spoke,
interference
Your
in a
Lordship,
writ
in the
appeal?
sense, Your Lordship, both the learned, Your Lordship, tribunal as well as the honorable single judge, Your Lordship, did not look into one aspect, Your Lordship. The learned tribunal, while passing the award, Your Lordship, applied the ratio laid down in Umadevi, Your Lordship, which essentially, Your Lordship, relating to regularization of service, Your Lordship. But our case, in fact, was, Your Lordship, for reinstatement and saying that, Your Lordship, although they are saying that this is we are under contract labor, Your Lordship, but that is not the case, Your Lordship. And that aspect, more particularly whether it is a camouflage or not, Your Lordship, that should have been looked into by the, Your Lordship, industrial tribunal. That aspect has not gone into, Your Lordship. This is
Who is
precise.
the employer? APCL, APGCL.
APGCL, Your Lordship.
You are for the
originally
APGCL?
I am for the APDCL, my lords, it's generation, for the power distribution.
Who's the employer precisely?
They were earlier appointed by the State Electricity Board, my lords. They're ACB. Thereafter, my lords, the board was trifurcated, my lords. Now they was when the dispute arose, my lords, they were employees of the APGCL. my lords, generation, power
APGCL.
generation, my lords.
So that corporation you are representing?
No, my lords, my senior, Mr. Dina, perhaps will appear, my lords.
Madam.
I'm appearing for Mr. Dina, government advocate.
So you will be.
May be taken up tomorrow, Lordship, if your Lordship will.
We'll have it tomorrow.
Tomorrow, Your Lordship,
No, Saturday you don't plan to work.
No, Your Lordship, I have some.
I
other
can, otherwise, my
engagement
lords, I've
already.
gone through the matter, I can assist my lord, if my lord deems fit.
So, all right, then we are happy with that. There's no problem at all.
But I'm not the standing counsel for the generation, my lord.
Then we don't know, Mr. Nath may have something else to say about it. He has jointly re-notified on 17th August.
Lords.
Deeply obliged.